All right, everyone. So this is my first stream actually, and I'm gonna have Mr. Deming on again. I had him on last week, and we talked about the first anniversary of January 6th. You should go back and check that episode out, and the previous ones I did with him. But today we're going to be talking about the Supreme Court rulings that came out today. There were two pretty major rulings. Oh, I think I just disappeared. We might have a few hiccups every once in a while. This is my first stream, and my Wi-Fi is not that strong. But they struck down the OSHA mandate, and there was another ruling upholding the mandate and allowing facilities with Medicare and Medicaid to continue to enforce the mandate. I think it requires them to. Not as many people are talking about that, but both Deming and I agree that that needs to be talked about more. I don't think today is as much of a win as everyone is saying that it is. So I'm going to bring in Mr. Deming, and we're going to talk about. I think it's good to start with maybe reminding people of the arguments that were made a week ago in the Supreme Court, because I think that it can kind of demonstrate just how close we are really to giving up all of our liberties in this country. The fact that we are at a position where we are waiting to hear if a majority of 9 people protect our liberty is kind of crazy to me. So I don't know. You didn't watch all of the oral arguments. You just
No.
read a little bit about it. Okay.
I read some, and then I picked and choose on some of the stuff.
Okay. Yeah, I'll just breeze through a little of the highlights that I came up with. I saw some people just listing a bunch of the claims that a lot of the more liberal people in the court had made in the arguments. So Breyer said that the vaccine mandate would prevent 100% of U.S. cases of COVID. That was a claim that was made in the arguments. Sotomayor said 100,000 children in critical care and on ventilators, that there are 100,000 children in critical care right now. And that got to the point where even CNN fact checked them. So that's how bad it is, that they're so, unwilling to just stay truthful about this. And they're willing, I saw somewhere that they're willing to fact check all things that cause vaccine hesitancy. But I wonder if it's the other way around, where it's like any lie that promotes vaccines is okay, if that's really how they're operating. Because the fact that we would have a Supreme Court justice making a lie like that, to me, is just crazy. But it is good to see a lot of these fact checkers coming out and correcting her. And then Sotomayor also said that COVID deaths are at an all-time high, which is just not true. Kagan said it's beyond settled that vaccines and masks are the best way to stop the spread. I found it interesting. The first time she spoke, she made an argument very similar to, like, I hear this all the time. It's like you say something factual about COVID and you just get this response. It's, don't you know we're in a global pandemic? It's like, yes, like how could we not? And Kagan, that was kind of the spirit that guided her the whole time. Kagan also said that COVID vaccines stop transmission. Sotomayor said the federal government can mandate vaccines using its police power. One of her arguments was that she sees no distinction between state power and state police powers and the federal government's use of the interstate commerce clause, the powers that they get from that. And you and I have discussed this quite a bit, specifically the fact that they've used the interstate commerce clause to just grab as much power as possible. It's been used in some of the worst cases in U.S. jurisprudence. Rickard v. Filburn comes to mind. We've talked about that a lot before, where the Supreme Court literally made the argument that growing wheat on your own land affects interstate commerce because not selling it affects the market. Because if you would have sold it, it would have affected the market. So not selling it in the same way does. And they seized this guy's wheat during the Great Depression that he was growing on his own land. It was also used for Gonzalez v. Reich, where they said that the U.S. government could still prosecute marijuana cases in states that had legalized it. And this woman desperately needed marijuana. Her doctors had said that she needed it for her medical condition. I think you told me about that case, actually.
Yeah, we talked about it a little bit.
But yeah, it's just absolutely insane that they would say that. It's one of the first things that you learn in con law. Like, I just took a con law. I think I backed out again. I just took a con law class, and she was not, a conservative or anything. And one of the first things that you learn is that there is a strong distinction between state powers and federal powers. That's just clear. So the fact that these people are making those arguments from the court is kind of crazy. And then another thing that I had is that Sotomayor said that hospitals are nearing capacity. Kagan said that the vaccine mandate is the most geared to stopping the pandemic. And yeah, PolitiFact and CNN fact checked Sotomayor just because her claims were that crazy. I know that you had kind of cherry picked some of that stuff. Did you have any thoughts on that?
I've got a lot of stuff that we talked about. We should probably narrow it down in the interest of time to just really a couple of things. First, the assumption that the court has that they have any business telling people that they have to take this experimental vaccine or any vaccine, that it's absurd on its face. Even though that's the understanding of how the federal government operates or has been operating for 100 years or more, that's not even a question, that they can. And in fact, when the justice said, I don't see the distinction between the state's police powers and the federal government's powers. I don't see the difference there. She's not making anything up. She probably understands that there is no longer a legal distinction between the two, no matter what textbooks are supposed to say. I think that's the very first thing to remember. You go back to your first principles. Well, is the federal government supposed to have these powers or not? And if they aren't, then the Supreme Court errs whenever they assume they do. And in this case, they did make a huge error again. The other thing I think we should talk about briefly is Associate Justice Sotomayor's contention that there's 100,000 children in critical care. And I don't think she said they're all on ventilators or even most of them, some of them on ventilators. Well, even what's the gal's name, Rochelle Walensky, came out and said, no, that's not true, Justice. So you either have one of two things, and there could be a third in there too, but we'll talk about one option. So she is either ignorant of the facts, which is terrifying. If they're going to make policy decisions, which, by the way, I don't think that they should make policy decisions based on what the outcome or probable outcome would be. If we don't rule this way, then these things will happen. No, you take a look at the Constitution and see how that applies. All right. So either she is ignorant of the actual facts or she's lying. And neither one of them is a good look for a Supreme Court justice, even an associate justice. Add to that, during the confirmation hearings, she said, I think we talked about this before, she actually made the statement that she had a better chance of rendering a just decision as an Hispanic grandmother than a bunch of white men on the court. Well, so she's either dumb, ignorant, lying, but she is absolutely racist. So I don't hold out much hope for Associate Justice Sotomayor.
Yeah, I mean, she definitely proved herself to be one of the worst justices on the court in this decision. And I think the benefit of this hearing is that a lot of people were listening to it. This is probably the first time where we've had this many people watching and waiting for a Supreme Court decision in a long time. Like, it's absolutely crazy how far the federal government was trying to, spread its tentacles. And I think I just wanted to cover a little bit more about the conservative case and what the more conservative justices were arguing for. Clarence Thomas actually mentioned a few times in the arguments that it wasn't really clear if the vaccine was, or there were some questions about the efficacy of the vaccine. I think he had brought up, and then Amy Coney Barrett, her main questions were when the mandate would sunset. Are we just going to allow like the executive agencies to kind of approach this in an ad hoc fashion, or when are we going to remove this authority from OSHA? When will the emergency powers be removed? That was her kind of main argument. And I think the main focus of the conservative justices were whether or not OSHA had ever had these powers before, or whether or not this was unprecedented and it was similar to other powers that they've used before. And this leads me to something else that Kagan said. She actually asked why a human is not like a machine if it is spewing virus. And I saw a funny thing about this is like this actually encapsulates the entire last 2 years. If you reduce man to a machine and that's all you think he is, then you can take whatever liberty from these people. Like that really becomes how you think of government, is that it's what Dostoevsky said is, man is not a piano key, but these people, and maybe it's because of the lack of religion or whatever. They truly don't think that there's any, it's almost like they can't see that there's like the image of God in them, that there's any reason that we would want to have liberty. So that's something that I also thought was important to bring up. She also said that this wasn't a vaccine mandate and Gorsuch wasn't wearing a mask, but 2 of the liberal judges attended on Zoom, I believe. So I think maybe we should actually read the decision. I think it might be interesting to go through and show the main opinion, and then the concurring opinion, and then the dissents, just to kind of show the different philosophies here. Because I think you and I would both agree that even the conservatives on the court have some problems, but we might agree with them a little more. But I've read the dissent already, and it just shows you how progressives, Democrats, people who believe that the Constitution is a living document, how they really think of government. So I'm going to just open this up and start reading. But do you have any more thoughts on what I just brought up?
No. Okay. Let's go ahead and roll.
Okay. Just want to make sure I have the right one. All right, so it was a 6-3 decision, and here it is. The Secretary of Labor, acting through the Occupational Safety and Health Administration recently enacted a vaccine mandate for much of the nation's workforce. The mandate, which employers must enforce, applies to roughly 84 million workers, covering virtually all employers with at least 100 employees. It requires that covered workers receive a COVID-19 vaccine, and it preempts contrary state laws. The only exception is for workers who obtain a medical test each week at their own expense and on their own time, and also wear a mask each workday. OSHA has never before imposed such a mandate. So there you start to see a little bit about what the conservative side of the court is thinking. Nor has Congress. Indeed, although Congress has enacted significant legislation addressing the COVID-19 pandemic, it has declined to enact any measures similar to what OSHA has promulgated here. Many states, businesses, and nonprofit organizations challenged OSHA's rule in Court of Appeals across the country. The Fifth Circuit initially entered a stay, but when the cases were consolidated before the Sixth Circuit, the court lifted the stay and allowed OSHA's rule to take effect. Applicants now seek emergency relief from this court, arguing that OSHA's mandate exceeds its statutory authority and is otherwise unlawful. Agreeing that applicants are likely to prevail, we grant their applications and stay the rule. So they did stay the rule, and then we get a little into their opinion. It's interesting here. you kind of get hints at the framework that they're going to look at this case. That it was argued on the basis that it exceeds the statutory authority of OSHA, not whether or not OSHA has constitutional powers to do this anyway. It's just, has Congress given them these powers, not whether or not Congress was able to or anything like that. It's just, we're gonna think very narrowly here, which sometimes is very helpful, that they're not just steamrolling the whole thing. And please interrupt if you have any thoughts too.
Well, I do have one to start. So the question comes up then: does the Supreme Court mean to say that had the legislature given the OSHA statutory authority, then that would have been constitutional? I don't think there's any question that that's what they're telling. And so from now on, as long as Congress, and now they know this, and I'm kind of stealing somebody's opinions or thoughts from one of the threads I was on today. Now that Congress knows that, they're going to be more deliberate in the way they write their laws so that they get past constitutional muster. So it's almost a signal to the legislature to unleash the power of the federal bureaucracy, as long as they give the go ahead.
And we also learned that Tester actually wants to get rid of the filibuster. We learned that today.
Yeah, I heard that.
I mean, if they're able to do that, like what the court has essentially said is, if Congress, which a lot of the conservative justices think of as like the democratic branch of government, so they think it's the voice of the people. So which I understand, and I understand the spirit of. They're separating that power from the Supreme Court and giving it to Congress, which is, I recognize and I empathize with that position. But if Congress were to pass a legislation, they would say that it is the voice of the people when it's clearly not.
Right.
But yeah, I'll keep reading here. It says, Congress enacted the Occupational Safety and Health Act in 1970. The act created the Occupational Safety and Health Administration, which is part of the Department of Labor and under the supervision of its secretary. As its name suggests, OSHA is tasked with ensuring occupational safety, that is, safe and healthful working conditions. And occupational is italicized there, so you are starting to see where they're going with that. It does so by enforcing occupational safety and health standards promulgated by the secretary. Such standards must be reasonably necessary or appropriate to provide safe or healthful employment. And this kind of, in employment is italicized again. This kind of shows you how justices think. They're creating standards that have been previously used in Supreme Court decisions. They're not looking at the text of the law. It's just, Congress has democratically passed this piece of legislation. And in that way, the people have given OSHA this authority. This is the standard that we have used in the past. They're not looking at, does Congress have this authority in the first place? Which is always interesting, just like how stare decisis, they're always going to look at these standards that have been used. They must also be developed using a rigorous process that includes notice, comment, and an opportunity for a public hearing. The Act contains an exception to those ordinary notice and comment procedures for emergency temporary standards. Such standards may take immediate effect upon publication in the Federal Register. They are permissible, however, only in the narrowest of circumstances. The Secretary must, 1, show that employees are exposed to grave danger from exposure to substances or agents determined to be toxic or physically harmful, or from new hazards, and 2, show that the emergency standard is necessary to protect employees from such danger. Prior to the emergence of COVID-19, the Secretary had used this power just 9 times before, and never to issue a rule as broad as this one. Of those 9 emergency rules, 6 were challenged in court, and only 1 of those was upheld in full. On September 9, 2021, President Biden announced a new plan to require more Americans to be vaccinated. Remarks on the COVID-19 response and national vaccination efforts 2021. As part of that plan, the president said that the Department of Labor would issue an emergency rule requiring all employers with at least 100 employees to ensure their workers are fully vaccinated or show a negative test at least once a week. The purpose of the rule was to increase vaccination rates at businesses all across America. In tandem with the other planned regulations, the administration's goal was to impose vaccine requirements on about 100 million Americans, 2/3 of all workers. After a 2-month delay, the Secretary of Labor issued the promised emergency standard. Consistent with President Biden's announcement, the rule applies to all who work for employers with 100 or more employees. There are narrow exemptions for employees who work remotely 100% of the time or who work exclusively outdoors. But those exemptions are largely illusory. The Secretary has estimated, for example, that only 9% of landscapers and groundskeepers qualify as working exclusively outside. The regulation otherwise operates as a blunt instrument. It draws no distinctions based on industry or risk of exposure to COVID-19. Thus, most lifeguards and linemen face the same regulations as do medics and meat packers. OSHA estimates that 84.2 million employees are subject to its mandate. Covered employers must develop, implement, and enforce a mandatory COVID-19 vaccination policy. The employer must verify the vaccination status of each employee and maintain proof of it. The mandate does contain an exception for employers that require unvaccinated workers to undergo weekly COVID-19 testing and wear a face covering at work in lieu of vaccination. But employers are not required to offer this option, and the emergency regulation purports to preempt state laws to the contrary, which I didn't know. I didn't know that they weren't required to give that option.
Yeah, I didn't either.
But
I've got a note here.
Yeah, go ahead.
So this whole state law preemption is an interesting concept. You can probably imagine how I feel about that. But to me, this one size fits all for every state it's just insanity on its face. It's insane. Montana, Idaho, Wyoming, North and South Dakota, they have different requirements than California, New York, and maybe different fear factors too. I don't really know. But to impose a mandate like this across the country and then limit it at 100, so 99 you're safe, 99 employees are fine. So the rule is a farce. Now I think everybody understands that. So we have to go to the Supreme Court for them to say, this is really a farce. I mean, why can't we decide that on our own? Why can't a business with 120 employees say, nah, we're not going to mandate the vaccine? And then a company down the street with 120 vaccines or 120 employees, we are going to. That's the way it should work. And then if those employers work in those companies that require a vaccine, if those people say, I don't want to work there anymore, well, that's the market deciding that for us. We shouldn't have to go to the Supreme Court to make these decisions, and this should never have been imposed. A president should never have even dreamed that this would have been something as acceptable. I couldn't help myself. Sorry.
Yeah, and that's really the question here, though, is like, who has the authority? I think I don't know if they get it into it in the main opinion, but I think they might in the concurring opinion. Just about who has the authority here. What really this case came down to was whether or not an executive branch, so the president through an executive branch, can rule by edict. Like that's really what this case came down to.
Yeah.
And the question isn't whether or not this is a good policy. It's not whether or not it's reasonable that we would do these things.
Right.
It's, does the Supreme Court and does the government have the authority to do this? The Supreme Court never seems to, at least like the conservatives seem to, but especially the more progressive side of the court never seems to distinguish between what's a well-reasoned argument and what the government has power to do. Like it just, for some reason, they're like, yeah, it would make sense that we do this, therefore the government can enforce it. It's like no one has ever, it has never been the case that the government was supposed to work this way. And especially the Democrats, they think of the court as just another legislative body. The conservatives aren't great at it either, but like they just think that it's another body to force whatever their policy prescriptions are. And, if they can't get it through the legislature, they're just going to do it through the court, 9 people. And they're supposedly the ones who are in favor of democracy. It doesn't make any sense.
No, it doesn't. So you said 9 people. If the court continues to strike down the Biden agenda, it'll be 13 or 15.
Yeah.
And then you lose the filibuster in the Senate thanks to John Tester. And so restraints. There'll be no restraints on the power of the general government whatsoever if those things happen. Add to that H.R. 1, which they're going to try to ram through. That's the reason they're getting rid of the filibuster. This is not going to be America. I mean, it hasn't been for a while, but everyone will recognize it then. So,
yeah. Well, let's continue reading. It says, but employers are not required to offer this option, and the emergency regulation purports to preempt state laws to the contrary. Unvaccinated employees who do not comply with OSHA's rule must be removed from the workplace. And employers who commit violations face hefty fines up to $13,653 for a standard violation and up to $136,000 and $532 for a willful one. That's up to $140,000 just for one violation. OSHA published its vaccine mandate on November 5th, 2021. Scores of parties, including states, businesses, trade groups, and nonprofit organizations, filed petitions for review, with at least one petition arriving in each regional court of appeals. The cases were consolidated to the Sixth Circuit, which was selected at random pursuant to, and then a piece of legislation. I'm terrible at reading that. A piece of legislation. Prior to consolidation, however, the Fifth Circuit stayed OSHA's rule pending further judicial review. It felt that the mandate likely exceeded OSHA's statutory authority, raised separation of powers concerns in the presence of a clear delegation from Congress, and was not properly tailored to the risks facing different types of workers and workplaces. When the consolidation cases arrived at the Sixth Circuit, 2 things happened. First, many of the petitioners, nearly 60 in all, requested initial hearing. Second, OSHA asked in the Court of Appeals to vacate the Fifth Circuit's existing stay. The Sixth Circuit denied the request for initial hearing en banc. I don't know what that means. I don't know. Do you know Latin?
Just that. So it means that the circuit court met together.
Okay.
All the members.
By an evenly divided 8-8 vote. Chief Judge Sutton dissented, joined by 7 of his colleagues. He reasoned that the Secretary's broad assertions of administrative power demand unmistakable legislative support, which he found lacking. A third judge panel then dissolved the Fifth Circuit stay, holding that OSHA's mandate was likely consistent with the agency's statutory and constitutional authority. Various parties then filed applications in this court requesting that we stay OSHA's emergency standard. We consolidated 2 of these applications, one from the National Federation of Independent Business and one from a coalition of states, and heard expedited arguments on January 7th, 2022. The Sixth Circuit concluded that a stay of the rule was not justified, and we disagree. Applicants are likely to succeed on the merits of their claim that the Secretary lacked authority to impose the mandate. Administrative agencies are creatures of statute. They accordingly possess only the authority that Congress has provided, and we would argue, and what the Constitution allows Congress to provide. But
Right.
they're not going to go that far. The Secretary has ordered 84 million Americans to either obtain a COVID-19 vaccine or undergo weekly medical testing at their own expense. This is no everyday exercise of federal power. It is instead a significant encroachment into the lives and health of a vast number of employees. We expect Congress to speak clearly when, and then they're quoting another case. We expect Congress to speak clearly when authorizing an agency to exercise powers of vast economic and political significance. There can be little doubt that OSHA's mandate qualifies as an exercise of such authority. The question then is whether the Act plainly authorizes the Secretary's mandate. It does not. The Act empowers the Secretary to set workplace safety standards, not broad public health measures. So that kind of goes to why they were like italicizing occupational earlier.
Right.
Or they're making it clear that like OSHA doesn't have the power to regulate pandemics or public health. It's specifically the workplace.
Health,
Yeah.
yeah.
Yeah. All right. And then a bunch of citations. And then they cite a piece of legislation that says it directs the secretary to set occupational safety and health standards, authorizing the secretary to impose emergency temporary standards necessary to protect employees from grave danger in the workplace. Confirming the point, the Act's provisions typically speak to hazards that employees face at work, and no provision of the Act addresses public health more generally, which falls outside the OSHA's sphere of expertise. I'm gonna just wait every time that I cut out because I keep cutting out a little bit, so I might pause every once in a while.
That's fine.
The dissent protests that we are imposing a limit found no place in the governing statute, and that was Breyer, Sotomayor, and Kagan. Not so. It is the text of the agency's organic act that repeatedly makes clear that OSHA is charged with regulating occupational hazards and the safety and health of employees. The Solicitor General does not dispute that OSHA is limited to regulating work-related dangers. So they're just going to say that they do have these powers, not going to question the constitutionality, just if Congress has given them again.
Right.
She instead argues that the risk of contracting COVID-19 qualifies as such a danger. We cannot agree. Although COVID-19 is a risk that occurs in many workplaces, it is not an occupational hazard in most. COVID-19 can and does spread at home, in schools, during sporting events, and everywhere else that people gather. That kind of universal risk is no different from the day-to-day dangers that all face from crime, air pollution, or any number of communicable diseases. Permitting OSHA to regulate the hazards of daily life simply because most Americans have jobs and face those same risks while on the clock would significantly expand OSHA's regulatory authority without clear congressional authorization. That seems clear to me. The dissent contends that OSHA's mandate is comparable to a fire or sanitation regulation imposed by the agency, but a vaccine mandate is strikingly unlike the workplace regulations that OSHA has typically imposed. A vaccination, after all, cannot be undone at the end of the workday. Contrary to the dissent's contention, imposing a vaccine mandate on 84 million Americans in response to a worldwide pandemic is simply not part of what the agency was built for. That is not to say OSHA lacks authority to regulate occupation-specific risks related to COVID-19, where the virus poses a special danger because of the particular features of an employee's job or workplace. Targeted regulations are plainly permissible. We do not doubt, for example, that OSHA could regulate researchers who work with the COVID-19 virus. So too could OSHA regulate risks associated with working in particularly crowded or cramped environments. But the danger present in such workplaces differs in both degree and kind from the everyday risk of contracting COVID-19 that all face. OSHA's indiscriminate approach fails to account for this crucial distinction between occupational risk and risk more generally. And accordingly, the mandate takes on the character of a general public health measure rather than an occupational safety or health standard. It's very interesting because you kind of brought up this point earlier that if they had chosen to do this in another agency that could, conceivably have these powers, within the framework that the Supreme Court is arguing right now, it would be totally justified if it's within the statutory limitations of that agency, which is terrifying. And that's why, we would argue that the argument really has to be on the basis of the constitutional authority, not whether or not Congress, they're not going that broad. They're arguing very narrowly that Congress has given this authority democratically, they would say. And that seemed to be a theme throughout a lot of the more conservative interpretations of the court.
Yeah. So a couple things occur to me in the middle of that. In the first place, let's just assume for our argument that the vaccines work, and that the COVID is the deadly pandemic that we've been led to believe, even though I don't think that's necessarily true. Let's just assume that. Like we talked about before, I just don't think that even in the case of a deadly virus, that the Congress can regulate individuals' lives in the way that they're trying to do, and the Supreme Court is essentially saying it's okay for them to do. I don't buy that. And so that's something, I think that's an argument that's missed by the court right here. If they had given statutory authority, as you said, to the right agency, then they would have probably said that's fine. But then, okay, so, we have first principles. We keep coming back to that. Majority rule, minority rights. So yeah, the Congress could probably say, all right, everybody has to take a vaccine, mandated for everybody in the country. Where minority rights come in that? So that's a two-part idea with our first principles. Majority rule, but minority rights. Like Arnold Schwarzenegger said, blank your rights. Did you hear that, what he said about it?
Yeah.
Okay. Well, that's the prevailing attitude. And I'm afraid that at least some of the justices on the Supreme Court, they would agree with that sentiment. So.
Yeah. And it's important maybe to clarify like what bodies we think can protect minority rights. I think my stance would be that this is where the states come in. They would say that the Congress is totally within its powers to pass a statute that gives an agency this authority. They would say that, but I would say that the states then have the ability to nullify that to protect minorities. I don't know if they would go that far. But what I can say is that regardless of whether or not they go that far or whether or not the Constitution allows it, I think it does. We can. Like we discussed this in the last one. There have been plenty of examples of states nullifying federal law, even when the court upholds such a thing. So like DC v. Heller, I think you told me about. Think of all of the states that regulate firearms beyond what DC v. Heller says. Also, just any marijuana law, any marijuana law that was upheld by the courts. Gonzalez v. Reich was held up by the court. And still Colorado, how long has it been? They've been selling weed in Colorado for how long? Montana now does it. So
and Washington State.
Yeah.
I think they've legalized virtually all quote unquote illegal substances that are illegal on the federal level. I think even heroin, crack cocaine, I don't know. Washington State has just said, well, the heck with the federal government on these things. And so the precedent is there. And it's interesting that whenever a quote unquote red state threatens to nullify a law, the very first critics are Colorado and Washington State.
Yeah.
Anyway,
yeah. I remember I posted something somewhere on social media and I said, conservative states need to start taking, just learning from those states and start to nullify like gun laws and stuff like this. And someone responded to me. They're like, well, how dare you compare gun rights with, weed laws or something like that. And I was like, well, don't you know how analogies work? It's like we're comparing the principle here. We're not, I'm not saying that guns are the same thing as it's just it's ridiculous. And that's kind of how their theory of governance is. It's just in a very ad hoc fashion. It's very utilitarian. It's not based in principle ever. It's whatever we like right now. We're going to use the Supreme Court to do it. We're going to use a state to do it. We're going to use the federal government to do it, but there's no principle.
No.
But yeah, let's keep reading and get to the concurrence. So finishing this, it says, In looking for a legislative support for the vaccine mandate, the dissent turns to the American Rescue Plan Act of 2021. That legislation signed into law on March 11th, 2021, of course, said nothing about OSHA's vaccine mandate, which was not announced until 6 months later. In fact, the most noteworthy action concerning the vaccine mandate by either House of Congress has been a majority vote of the Senate disapproving the regulation on December 8th, 2021. So they're still talking within the bounds of, as long as Congress passes this, it's all right. It is telling that OSHA, in its half century of existence, has never before adopted a broad public health regulation of this kind, addressing a threat that is untethered in any causal sense from the workplace. This lack of historical precedent, coupled with the breadth of authority that the Secretary now claims, is a telling indication that the mandate extends beyond the agency's legitimate reach. The equities do not justify withholding interim relief. We are told by the states and the employers that OSHA's mandate will force them to incur billions of dollars in unrecoverable compliance costs and will cost hundreds of thousands of employees to leave their jobs, potentially millions, I would contend. For its part, the federal government says that the mandate will save over 6,500 lives and prevent hundreds of thousands of hospitalizations. OSHA response 83. I froze again. It is not our role to weigh such trade-offs. In our system of government, that is the responsibility of those chosen by the people through democratic processes. Although Congress has indisputably given OSHA the power to regulate occupational dangers, it has not given that agency the power to regulate public health more broadly. Requiring the vaccination of 84 million Americans selected simply because they work for employers with more than 100 employees certainly falls in the latter category. The applications for stays presented to Justice Kavanaugh and by him referred to the court are granted. OSHA's COVID-19 vaccination and testing emergency temporary standard is stayed pending disposition of the applicant's petitions for review in the United States Court of Appeals for the Sixth Circuit and disposition of the applicant's petitions for writs of cert. How do you pronounce that? We discussed this in class. Writs of certiorari?
Yeah, cert writs.
Cert
That's
writs.
the easy way out.
That's the way to do it. If such writs are timely sought. Should the petitions for cert writs be denied, this order shall terminate automatically. In the event the petitions for cert writs are granted, the order shall terminate upon the sending down of the judgment of this court. It is so ordered. And then we have the concurrence. Do you have any more thoughts before we get to the concurrence?
Yeah. So another almost first principle, I think. The question comes up once in a while. You don't hear it very often because it's just an assumed thing now. But can Congress actually delegate its authority to another entity like the bureaucracy? I don't think they can or should. Maybe that's a better way of saying it. But look at where we've come now. And now these agencies, like OSHA, they're given deference in the court system. So whatever they think is actually a standard that the court uses to decide what is and what isn't allowed. So not only you remove the authority from Congress for that, you've granted an authority that is certainly not constitutional to these bureaucracies. And it just occurs to me every time we talk about something like this, we give deference. Courts give deference to those people, and they shouldn't.
And it's my understanding that what we give deference to them for is the interpretation of their powers too. It's right. It's whatever Congress has delegated to them. They have the authority to interpret that, and the courts will defer to that interpretation.
Right.
Yeah. And that's easily how this could have gone.
Yes, absolutely.
Yeah. And I think the concurring opinion actually gets a little bit into I forget what the doctrine is. They'll bring it up. Well, I think
Okay.
it's called the Major Questions Doctrine.
Yes. Yep.
Okay. So it's the concurring opinion is Gorsuch, Thomas, and Alito. The central question we face today is who decides? No one doubts that the COVID-19 pandemic has posed challenges for every American, or that our state, local, and national governments all have roles to play in combating the disease. The only question is whether an administrative agency in Washington, one charged with overseeing workplace safety, may mandate the vaccination or regular testing of 84 million people. Or whether, as 27 states before us submit, that work belongs to state and local governments across the country and the people's elected representatives in Congress. This court is not a public health authority. I love it. So they're saying we just can't decide this. But it is charged with resolving disputes about which authorities possess the power to make the laws that govern us under the Constitution and the laws of the land. So they right up front, they're saying that the question here isn't whether or not this is a good policy. It's who has the authority to implement this policy. Who has the say here?
And that is the question that they should ask.
Yes.
It's whether it's effective or not doesn't matter. It's the actual constitutional principle that they should be deciding on, and that's why the dissents are so ridiculous, because they're all worried about the effect that this decision is going to have on people. Well, okay, we can worry about that, but that doesn't, take away your responsibility to interpret the Constitution as written. So.
Yeah, I froze again. So he continues, I start with this court's precedents. There is no question that state and local authorities possess considerable power to regulate public health. They enjoy the, quote, general power of governing, including all sovereign powers envisioned by the Constitution and not specifically vested in the federal government. And in fact, states have pursued a variety of measures in response to the current pandemic. The federal government's powers, however, are not general but limited and divided. See McCullough v. Maryland. Not only must the federal government properly invoke a constitutionally enumerated source of authority to regulate in this area or any other, it must also act consistently with the Constitution's separation of powers.
Hang on.
Okay. Do you want me to keep reading?
I'm going to take a break here. I'm going to take a quick break. Hang on.
Okay. We'll just wait for him to get back. I see that there's 2 people watching right now. I'm glad this stream is working out. I've had a few interruptions, but this is my first time actually streaming. Please go listen after the stream to my previous podcast with Mr. Deming. I've done 3 now. I interviewed him, and then we did a July 4th episode where we read the Declaration of Independence, and then we did another about January 6th last week. And today we're talking about the Supreme Court decisions that came out today. Just reading through the decision if you're just now checking in. And remember to go subscribe to me on Apple Podcasts, Spotify, YouTube, wherever else. I'm also on Twitter and Instagram. My handle is mliammccullum. But yeah, we'll just wait for Deming to get back. All right. You ready?
Ready.
Okay. Do you have any more thoughts about what was said? I do appreciate that he's just appealing to the enumerated powers. It's just that his interpretation of the enumerated powers are incorrect. The fact that he thinks, or I think it is, that he thinks that OSHA that Congress would even have the authority to create an institution and, like you said, um, give up power in that way.
Right. So I think you're right, but at least a um, Supreme Court justice is actually saying things like enumerated powers. It's not very often that we hear that. Do you have time for a kind of an anecdote?
Yeah,
I
go
was
ahead.
kind of laughing at myself. I was reading about Clarence Thomas and some of the things that he said recently, particularly with the response to the coronavirus. And he hasn't said a lot in some ways, but anyway, I was thinking how much I appreciated the guy. And then I realized that the guy's black. So here I am, maybe a middle-aged white guy of privilege, and admiring a black guy. It just struck me as kind of odd that no one, I think, would appreciate that as much as somebody like me, who is a former conservative, now more libertarian than ever, who really appreciates this black justice. But I didn't recognize him necessarily as black.
Yeah.
I didn't care what color the guy was. So anyway, I just thought that was kind of funny.
It is hilarious that it's kind of ignored by the left, especially with his affirmative action cases. His opinion on affirmative action and stuff like that. He is one of the best justices I think we've had in a long time.
Yeah.
The only sad thing is that I cut out again. Can you hear me?
Yeah.
Okay. Yeah. He appears to really like executive authority. So I was kind of scared, honestly. I thought that he would rule in favor of the mandate just because he is in favor of executive authority, especially during, like kind of the Bush era type stuff, those type questions. It wasn't really clear.
Right. I think he's been good for a long time. In some ways, I like his interpretations better than Scalia, and I really liked Antonin Scalia. So anyway, I expected him to rule against this mandate, to be honest with you. And I did read his dissent in the other case, and I don't know that we'll have time, and I don't have a lot to add to that, but I do think he deserves quite a bit of credit in this case, in both cases.
If we get through, we can at least maybe talk about it or talk about the dissent, because I think it is important that we really talk about like how today wasn't a complete win. I think even just the fact that we were waiting to hear from the court is a sign that we aren't in the best of position. Like if Donald Trump didn't win, we would have had 3 liberal justices on the court, and this would look completely different.
Right. Absolutely. And that conversation that we heard last night by one of the members in that group, I think completely overlooks the positive outcome of the Trump presidency, and that is getting 3 justices on the Supreme Court who at least have a chance of seeing things not our way, but differently than the progressives in this country.
Yeah.
That this entire episode of a Biden presidency, the usurper in chief, his would have been different, and I think not for the better.
Yeah.
So say what you want about President Trump, but I think at least his appointments may have forestalled some of the horribleness that would have happened up to now during this time. I think it's terrifying to think about it. I don't even like to think about what would have happened.
Yeah. I mean, I've been trying to emphasize on Twitter, because a lot of people are excited. I really think that we really have to get to a point where the states do insist to protect minority rights. Because if we are at a position in this country where we really are just, everyone's waiting on on the edge of their seats just to hear what 9 lawyers have to say. I think that we've already almost lost. I mean, that's what I'm trying to just communicate, is that like we need the states to stand up. We need the states to protect minority rights, like you said earlier. But yeah, I'm gonna finish this concurring opinion. The federal government's powers, however, are not general but limited and divided. I'm going to skip down. We already read that part. I might read a little bit of what I already read. It must also act consistently with the Constitution's separation of powers. And when it comes to the obligation, this court has established at least one firm rule. We expect Congress to speak clearly if it wishes to assign to an executive agency decisions of vast economic and political significance. We sometimes call this the major questions doctrine. So the major questions doctrine is just a question of, whether or not courts should defer to agencies and their statutory interpretations that concern questions of, it says here, vast economic or political significance. So when there are political questions brought to the court, the conservative take is that we are not a political body. We defer to Congress, and then there's also the question of whether or not they defer to the agencies. OSHA's mandate fails that doctrine's test. The agency claims the power to force 84 million Americans to receive a vaccine or undergo regular testing. By any measure, that is a claim of power to resolve a question of vast national significance. Yet Congress has nowhere clearly assigned so much power to OSHA. Approximately 2 years have passed since this pandemic began. Vaccines have been available for more than a year. Over that span, Congress has adopted several major pieces of legislation aimed at combating COVID-19. Examples are the American Rescue Plan Act of 2021. But Congress has chosen not to afford OSHA or any federal agency the authority to issue a vaccine. Indeed, a majority of the Senate even voted to disapprove OSHA's regulation. It seems, too, that the agency pursued its regulatory initiative only as a legislative workaround. Far less consequential agency rules have run afoul of the major questions doctrine. It is hard to see how this one does not. What is OSHA's reply? It directs us to 29 USC, US Code 655C1. In that statutory subsection, Congress authorized OSHA to issue emergency regulations upon determining that employees are exposed to grave danger from exposure to substances or agents determined to be toxic or physically harmful, and that such emergency standards are necessary to protect employees from such dangers. According to this agency, this provision supplies it with almost unlimited discretion to mandate new nationwide rules in response to the pandemic, so long as the rules are reasonably related to the workplace. The court rightly applies the major questions doctrine and concludes that this lone statutory subsection does not clearly authorize OSHA's mandate. This piece of legislation was not adopted in response to the pandemic, but some 50 years ago at the time of OSHA's creation. Since then, OSHA has relied on it to issue only comparatively modest rules addressing dangers uniquely prevalent inside the workplace, like asbestos and rare chemicals. As the agency itself explained to a federal court less than 2 years ago, the statute does not authorize OSHA to issue sweeping health standards that affect workers' lives outside the workplace. Yet that is precisely what the agency seeks to do now: regulate not just what happens inside the workplace, but induce individuals to undertake a medical procedure that affects their lives outside the workplace. Historically, such matters have been regulated at the state level by authorities who enjoy broader and more general governmental powers. Meanwhile, at the federal level, OSHA arguably is not even the agency most associated with the public health regulation. And in the rare instances when Congress has sought to mandate vaccination, it has done so expressly. We have nothing like that here. Why does the major questions doctrine matter? It ensures that the national government's power to make the laws that govern us remain where Article 1 of the Constitution says it belongs, with the people's elected representatives. If administrative agencies seek to regulate the daily lives and liberties of millions of Americans, the doctrine says they must at least be able to trace that power to a clear grant of authority from Congress. In this respect, the major question doctrine is closely related to what is sometimes called the non-delegation doctrine. Indeed, for decades, courts have cited the non-delegation doctrine as a reason to apply the major questions doctrine. Both are designed to protect the separation of powers and ensure that any new laws governing the lives of Americans are subject to the robust democratic processes the Constitution demands. The non-delegation doctrine ensures democratic accountability by preventing Congress from intentionally delegating its legislative powers to unelected officials. Sometimes, lawmakers may be tempted to delegate power to agencies to reduce the degree to which they will be held accountable for unpopular actions. But the Constitution imposes some boundaries here. If Congress could hand off all its legislative powers to unelected agency officials, it would dash the whole scheme of our Constitution and enable intrusions into the private lives and freedoms of Americans by bare edict rather than only with the consent of their elected representatives. The president, oh, that's a case, or a case. They're citing a case right there. The major questions doctrine serves similar function by guarding against unintentional, oblique, or otherwise unlikely delegations of the legislative power. Sometimes Congress passes broadly worded statutes seeking to resolve important policy questions in a field while leaving an agency to work out the details of implementation. Later, the agency may seek to exploit some gap, ambiguity, or doubtful expression in Congress's statutes to assume responsibilities far beyond its initial assignment. The major questions doctrine guards against this possibility by recognizing that Congress does not usually hide elephants in mouse holes. In this way, the doctrine is a vital check on expansive and aggressive assertions of executive authority. Whichever the doctrine, the point is the same. Both serve to prevent government by bureaucracy supplanting government by the people, and he's citing Scalia. And both hold their lessons for today's case. On the one hand, OSHA claims the power to issue a nationwide mandate on a major question, but cannot trace its authority to do so to any clear congressional mandate. On the other hand, if the statutory subsection the agency cites really did endow OSHA with the power it asserts, that law would likely constitute an unconstitutional delegation of legislative authority. So he's actually saying that even if they did, it would be unconstitutional.
Yeah. Mm-hmm.
Under OSHA's reading, the law would afford it almost unlimited discretion and certainly impose no specific restrictions that meaningfully constrain the agency. OSHA would become little more than a roving commission to inquire into evils and upon discovery correct them. Either way, the point is the same one Chief Justice Marshall made in 1825. There are some important subjects which must be entirely regulated by the legislature itself, and others of less interest in which a general provision may be made and power given to others to fill up the details. And no one's account does this mandate qualify as some detail. The question before us is not how to respond to the pandemic, but who has the power to do so. The answer is clear. Under the law as it stands today, that power rests with the states and Congress, not OSHA. In saying this much, we do not impugn the intentions behind the agency's mandate. Instead, we only discharge our duty to enforce the law's demands when it comes to the question who may govern the lives of 84 million Americans. Respecting those demands may be trying in times of stress. But if this court were to abide them only in more tranquil conditions, declarations of emergencies would never end, and the liberties our Constitution's separations of powers seek to preserve would amount to little. I think that concurring opinion is amazing and spot on. Yes. I didn't expect them to get into the actual powers of Congress there too, and delegating authority, but I think they're spot on right there. And I think it differs a little bit from the controlling opinion. I think that it's more precise, and I'm very happy with it.
I think it covers more ground, but it did say, I can't remember exactly. I was trying to write while you're reading. It did say that Congress still has the power resides in the states and in Congress to legislate in response to COVID or a pandemic. Well, I don't think that's true.
And that's also very broad because I don't know what they mean. Like if Congress and the states have that authority, if Congress rules on it, can the states have a differing ruling or a different
Exactly.
opinion? So it's very broad there, but everything else I think was spot on with
Right.
OSHA's authority and Congress itself. But now we actually are getting to the dissent. I don't think the dissent's too long, but I would like to get through it just to kind of show what the more liberal interpretation of the court is. We've mentioned it a little bit before, but I think reading their actual words kind of will help draw that out, because as we mentioned earlier, that Sotomayor made no distinction between police powers of states and the power of Congress or of the federal government, and she seemingly hasn't read the Constitution. It'll be interesting to see how many times they actually mention the Constitution or separation of powers. I doubt they will, but it was good to see Gorsuch talk about it.
Yes, I agree. I hate to move on before we talk briefly about this one point, but so is it your assumption that reading that last part of the concurring opinion, is it your assumption that agencies that operate outside the scope of the law, who use more power than they're granted, no clear grant of authority, but continue to use that, that their actions are unconstitutional?
Yeah, and I think I'd be interested to see, like, Gorsuch seems to think that, which is, I think, great. I thought Gorsuch was the one where we weren't really sure about. I think all of the appointments, it wasn't really clear. I think Barrett was in the controlling opinion rather than the concurring one. So she doesn't appear to be taking as strong of a stance, but it's great to see that Gorsuch and Alito and yeah. Well, so Kavanaugh also would have been in the controlling opinion.
Should. I'm going to have to take a quick break again. I'm sorry.
Okay. Yeah, no problem. I think I might go back after this stream and edit out these spots afterwards, but we're just going to wait for him again, and then we're going to read the dissenting opinion. It should be interesting because this case, I think, is the perfect kind of example of the differing opinions and the different philosophies of how the federal government works and the court works. And it's super fascinating. So the dissenting opinion is exactly who you would expect it to be. It's Breyer, Sotomayor, and Kagan. But yeah, we'll just wait. Oh, he's back. All right, you ready? Can you hear me? Can you hear me? Maybe not. How about now? Can you hear me now? Someone in the chat who's watching live, let me know if you can hear us. This is my first live stream, so I knew that there would be some interruptions. It says Daniel can hear us. Can you hear me now? Sorry about this, guys. I don't know exactly what happened. We were just talking and he took a quick break and he can't hear me now. He's just gonna leave and then come back and that might work. All right. So he just left. If you guys tuned in a little late, we've been going for about an hour and 10 minutes now. We have read through the entire opinion um, for the OSHA case. And we just got to the dissenting opinion, and we're going to read through that when he gets back. There was also another case that was decided today. It was the Biden v. Missouri case. And we think that it probably needs to be highlighted just as much as this one because the scope of both of these cases aren't as broad as, or aren't as precise as we would really want them to be under our interpretation. And like I said earlier, it's just, I mean, it's the fact that we are even waiting for 9 people, unelected people, glorified lawyers, glorified philosophers, just to decide whether or not, you know, the federal government has the authority to do this is extremely concerning in the first place. It's like, I don't consider this a win that, you know, they, the government was just like, oh yeah, no, you can have a little bit of freedom. If the government is granting us freedom, if the government is the one who says, yeah, actually, no, we don't have the authority to do this, they're still in control. So the fact that we were even waiting on the edge of our seats for this opinion is concerning to me. And I don't consider this a complete win. It's a complete win when we're no longer looking to them, and it's the states, that are protecting rights and yeah. So or individuals. If individuals insist on their rights, then we have them. So um, that's kind of my thoughts, and I'm gonna just message him again just to see if he's trying to get on. All right, can you hear me now?
Yeah, I can hear you. I don't know what happened there, Liam. Sorry about that.
Yeah, no problem. There are people in the comments who said that StreamYard is pretty glitchy, and that they could hear me. So yeah, I was just telling them a little bit about our ideas about the court and how until we're no longer waiting for 9 justices and 9, you know, philosophers to give us a little bit of liberty, then we're not really free. But yeah, if you're ready, I'm gonna just start reading the dissenting opinion.
Yes. Yeah.
Okay. All right. So, like I said earlier, this is Breyer, Sotomayor, and Kagan dissenting. Says every day COVID-19 poses grave dangers to the citizens of this country and particularly to its workers. The disease has by now killed almost 1 million Americans and hospitalized almost 4 million. It spreads by person-to-person contact in confined indoor spaces, so causes harm in nearly all workplace environments. And in those environments, more than any others, individuals have little control and therefore little capacity to mitigate risk. COVID-19, in short, is a menace in work settings. The proof is all around us. Since the disease's onset, most Americans have seen their workplaces transformed. And goes back to what you were saying earlier. It's like, we could grant that this is true. Like, if you actually believe that this was true, that, it's continuingly to kill off Americans, and it's the worst that it's ever been, like Sotomayor had argued, then that's an argument that you can have, but this isn't the question here. The question of the court is, and always has been, who has the authority to do this? And if you have any thoughts while I'm reading, just feel free to interrupt.
Well, before we go on, I think that might even be framed a little bit inaccurately. No apologies, by the way.
Yeah.
And that is that,
Go ahead.
well, I think you believe this. We've talked about this before. Who gives a rat's about what the Supreme Court says? Ultimately, they can't enforce it. And this is clearly a government overreach, both mandates. I actually think that the court allowing the mandate for healthcare workers is as egregious as just about anything they've done, and for reasons we can talk about. But they can't enforce that decision. Just because it was 5-4, 5 justices say that they can, doesn't mean that they can, or that they should be able to. They don't have the authority to do it. They don't have the constitutional authority to tell anybody to take this vaccine. It's insanity, particularly now when, I mean, obviously, we've talked about the efficacy. Whether or not they're effective doesn't matter. I mean, they're terribly ineffective, and that is coming to light more and more. So the push to continue these vaccine mandates is even more ludicrous, in my opinion.
Yeah.
Now that we know how ineffective and, in fact, how dangerous they are.
Yeah, I've been saying, like, you don't want to make the argument hinge off of the efficacy of either, right? You want to you want to make your argument grounded in liberty and the principles of liberty and freedom. But I mean, the fact that they aren't, that doing that well, and like, the admissions that we've heard from the CDC just within the last 2 weeks, it's like it only strengthens our case. And totally agree. Oh yeah, I cut out again, but I totally agree. I think that really we are in a position where governors need to stand up and say, especially in Montana, it's a weird situation now where it's kind of unclear. Like, the court struck down this mandate, the OSHA mandate, so those people are okay. But is the law that was passed by Montana that prohibits vaccine discrimination, does that still conflict with this new ruling by the Supreme Court? So there's going to be this battle in our hospitals in Montana where, these facilities that get Medicare and Medicaid are going to likely appeal to the federal government because they're holding funds over their heads, and state law is completely counter to it. And it goes back to one of my previous podcasts that I did with Adam Thune, just the idea that reliance is compliance. And like, not only do we need to decentralize, we also need to just create completely separate systems. Right. We need the governor to say, like, well, no, our state has this position. We're going to continue to protect our rights. And I think there might be a silver lining to this case. The case that upholds the Medicare and Medicaid mandate, because what it might do is it might drive people out of these institutions, and we might create alternatives. If there are people who are really, like, they're holding to their principles, like Montana did pass some of the best free market healthcare legislation this session, and I think we're actually the best state when it comes to free market healthcare now. Yep. So we need, like, direct primary care institutions to just say, yeah, we're not offering Medicare and Medicaid, we're not taking it, and we're not going to implement the vaccine mandate. We are just not following suit. And that's why we need a strong governor or someone, or strong individuals, which is more preferable, who just stand up and say, we're not complying. I don't care what the federal government says. I don't care what the Supreme Court says. I don't care. I'm not waiting to hear what the Supreme Court says. I'm just not following. I insist upon my rights, so I'm taking my rights. And that really needs to be the principle, I think.
Yeah.
And I think that there might be a silver lining because of that.
Do you think there's going to be pushback?
I'm not sure. I don't know what the governor's position is going to be now.
Yeah, I don't either.
Ruling. I'm trying to get Jennifer Carlson. She's a legislator from Montana. She backed the vaccine discrimination piece of legislation, and I'm trying to get her on the show just to see what her thoughts are on this, and just like bounce around the ideas of nullifying a Supreme Court decision. See if she's in favor of it. See if the Gianforte administration seems to be in favor of it. It would be cool to at least start that dialogue here.
Mm-hmm. Yep. I get the feeling that Governor Gianforte, even though he's been pretty good on quite a few things, is pretty much like everybody else in America, and that is, well, the Supreme Court ruled. That's it. That's the end of it. Well, Dred Scott versus Sanford, Plessy versus Ferguson. They were, I guess the Supreme Court ruled. We're going to have to follow that.
Yeah.
So I think that there's some wiggle room for him, and I think he needs to use it, particularly in Montana. As he said, we're making such great progress in medical freedom initiatives. I'd hate to see us backslide now, and I'd hate to see Montana beholden in any way, shape, or form to the national government. Sonia Sotomayor, you kidding me? She doesn't even know what's going on, and she's going to make a decision based on either faulty information or a lie that she's told herself.
Yeah, if we could have another governor like Schweitzer who just says, okay, like pull funding, like do it.
Go ahead.
Yeah, because
don't let Montanans fly in planes. All right, fine.
and the chances are is that they don't, like we discussed in the previous podcast. I don't think that they would, but even if they do, we just don't want to be beholden to them, and we don't want to be reliant on them, because there are countless cases where they have threatened to pull funding because we wouldn't comply,
and we caved.
Yeah.
I don't blame us at all. It's a lot of money.
Yeah, and I think a lot of people are afraid of losing their jobs right now in the healthcare industry, but they're already kicking you out because of this mandate if you are sticking to your principles. So let's just let's take a stand. But yeah, let's get back to this ruling.
Sorry,
they haven't mentioned the Constitution yet, so we'll see how long it takes them.
Okay.
Okay, let's see where I was at. And notice how they're making rational arguments about like how bad the virus is and what we should do to prevent it, and they're not making constitutional arguments at all. So the administrative agency charged with ensuring health and safety in workplaces did what Congress commanded it to. It took action to address COVID-19's continuing threats in those spaces. The Occupational Safety and Health Administration issued an emergency temporary standard requiring either vaccination or masking and testing to protect American workers. The standard falls within the core of the agency's mission to protect employees from grave danger that comes from new hazards or exposure to harmful agents. OSHA estimates, and there is no ground for disputing, that the standard will save over 6,500 lives and prevent over 250,000 hospitalizations in 6 months' time. Yet today,
excuse me, hang on. That's pretty specific numbers. I wonder how OSHA came up with those. Did they ask Anthony Fauci?
I'm sure they did. I do wonder what agency or what media companies they're listening to, because it's like CNN fact checked them on the child hospitalization stat. So who are they listening to?
I don't know.
Yet today, the court issues a stay that prevents the standard from taking effect. In our view, the court's order seriously misapplies the applicable legal standards And in so doing, it stymies the federal government's ability to counter the unparalleled threat that COVID-19 poses to our nation's workers. So it's interesting. They are, again, appealing to legal standards and just these contrived things that these philosophers have come up with in their minds, that have no basis in the Constitution. It's just rational arguments that they came to themselves and that they continue to appeal to. And you can find standards that point towards whatever belief you want. Like if you want to argue that this mandate isn't justified, you could find a standard that helps support that. Like there's so many precedents throughout the court's history that they could appeal to, and it just shows why, like, if you don't have jurisprudence based in the Constitution, then like it's just anything that one justice believes.
Right. Can I interject something here that I think appropriate?
Yeah, go ahead.
So, over the course of our history, has the general government, national government, gotten more or less powerful? Well, it's gotten considerably more powerful. So, which of the branches is supposed to keep that in check? Well, it's supposed to be the judicial branch. And so they have actively made the federal government more and more powerful over our history. So that's a huge indictment, right? So just looking at it from that standpoint, what you just said, I think you can go back and read that in your head and say, oh, yeah, that's too bad.
Yeah, read that comment really quick. That's my friend Daniel. I'm going on his podcast tomorrow.
Okay.
Says, what's the Constitution? Is that a brand of toilet paper?
Mm-hmm. Well, some people treat it like that. I think you and I have more reverence for it, but Lysander Spooner 130 years ago said, I'm not so sure.
Yeah.
Okay, let's go on.
Well, what is interesting, I'll make another point on that, is like, so in a certain sense, the progressives on the court will say the Constitution doesn't matter in a certain sense. It's old, it's an ancient document, whatever, but they're still using the institutions that the Constitution created. So they're like, in a sense, appealing towards it and using the institutions created by the Constitution, but expanding it. So it's like where our argument, if we are to appeal to the idea that the Constitution isn't legitimate because we haven't consented to it, if we were to make that, more libertarian argument, we would say, well, so the institutions go too. They're
Right.
not going to go that far. It's more of like an anarcho tyranny system where they're like, well, the Constitution doesn't matter, but we're still going to use this tool, this gun.
Right. That's good analysis.
But all right, let's see where I was at. Acting outside of its competence and without legal basis, the court displaces the judgments of the government's officials given the responsibility to respond to workplace health emergencies. We respectfully dissent. In 1970, Congress enacted the Occupational Safety and Health Act to assure so far as possible every working man and woman in the nation safe and healthful working conditions and to preserve our human resources, including by developing innovative methods, techniques, and approaches for dealing with occupational safety and health problems. To that end, the Act empowers OSHA to issue mandatory occupational safety and health standards applicable to business affecting interstate commerce. Still more, the Act requires OSHA to issue an emergency temporary standard to take immediate effect upon publication in the Federal Register if the agency determines A, that employees are exposed to grave danger from exposure to substances or agents determined to be toxic or physically harmful or from new hazards, and B, that such emergency standard is necessary to protect employees from such danger. Acting under that statutory command, OSHA promulgated the emergency temporary standard at issue here. The standard obligates employers with at least 100 employees to require that an employee either 1, be vaccinated against COVID-19, or 2, take a weekly COVID-19 test and wear a mask at work. The standard thus encourages vaccination but permits employers to adopt a masking or testing policy instead. The majority obscures this choice by insistently calling the policy a vaccine mandate. Further, the standard does not apply in a variety of settings. It exempts employees who are at a reduced risk of infection because they work from home, alone, or outdoors. It makes exceptions based on religious objections or medical necessity, and the standard does not constrain any employer able to show that its conditions, practices, means, methods, operations, or processes made its workplace equivalently safe and healthful. Consistent with statutory requirements, the standard lasts only 6 months. Multiple lawsuits challenging the standard were filed in the federal courts of appeals. The applicants asked the courts to stay the standard's implementation while their legal challenges were pending. The lawsuits were consolidated in the Court of Appeals for the Sixth Circuit. That courts dissolved a stay previously entered, thus allowing the standard to take effect. The applicants now ask this court to stay the standard for the duration of the litigation. Today, the court grants that request contravening clear legal principles and itself causing grave danger to the nation's workforce. The legal standard governing a request for relief pending appellate review is settled. To obtain that relief, the applicant must show, 1, that their claims are likely to prevail, 2, that denying them relief would lead to irreparable injury, and 3, that granting relief would not harm the public interest. So there's just another standard that they've made up that they're going to implement. And to say that there isn't any irreparable injury, I think the controlling opinion actually demonstrated that there is.
Yeah, in fact, they were pretty. I think somebody was pretty clear that they get the vaccine for work, right? And then they can't unvaccinate themselves to go home. So regardless, the effect is full time. It's not just while they're at work.
Yeah.
I can't remember who said that.
Yeah, it was in the controlling opinion, the main one. I don't think the concurring opinion brought that up. But they also did mention that, like, all of the legal fees, the compliance fees. But continuing, moreover, because the applicants seek judicial intervention that the Sixth Circuit withheld below, this court should not issue relief unless the applicants can establish that their entitlement to relief is indisputably clear. Another standard that just pull out of their heads. None of these requirements is met here. The applicants are not likely to prevail under any proper care view of the law. OSHA's rule perfectly fits the language of the applicable statutory provision. Once again, that provision commands, not just enables, but commands OSHA to issue an emergency temporary standard whenever it determines A, that employees are exposed to grave danger from exposure to substances or agents determined to be toxic or physically harmful, or from new hazards, and B, that such emergency standard is necessary to protect employees from such danger. Each and every part of that provision demands that in the circumstances here, OSHA act to prevent workplace harm. The virus that causes COVID-19 is a new hazard as well as a physically harmful agent. Merriam-Webster's Collegiate Dictionary. No way. So they're gonna appeal to precedent that they've discussed before, as well as the Collegiate Dictionary, before they even talk about the Constitution. I don't think they've mentioned the Constitution once.
Yeah, I haven't heard anything.
So yeah, they're just defining all the terms that they've talked about as agent, chemically, physically, or biologically active principle, defining virus as the causative agent of an infectious disease. The virus also poses a grave danger to millions of employees. As of the time OSHA promulgated its rule, more than 725,000 Americans had died of COVID-19 and millions more had been hospitalized. Since then, and they're citing the CDC, since then, the disease has continued to work its tragic toll. In the last week alone, it has caused or helped to cause more than 11,000 new deaths, citing the CDC again. And because the disease spreads in shared indoor spaces, it presents heightened dangers in most workplaces. Finally, the standard is necessary to address the danger of COVID-19. OSHA based its rule requiring either testing and masking or vaccination on a host of studies and government reports showing why those measures were of unparalleled use in limiting the threat of COVID-19 in most workplaces. The agency showed in meticulous detail that close contact between infected and uninfected individuals spreads the disease, that the science of transmission does not vary by industry or by type of workplace, that testing, mask wearing, and vaccination are highly effective, indeed, essential tools for reducing the risk of transmission, hospitalization, and death. And the unvaccinated employees of all ages face a substantially increased risk from COVID-19 as compared to their vaccinated peers. It's like cool, and like that's the question here. It's really great. You've provided stats that may or may not be real. And that really is the question. What's the authority? In short,
Yeah.
OSHA showed that no lesser policy would prevent as much death and injury from COVID-19 as the standard would. Yeah, what do you think about that so far? It's getting a little worked up there.
Right. With good reason. So I have a question. Do you think that OSHA approached President Usurper-in-Chief Biden and said, well, we got this problem and I think we can deal with it. We're the agency. Or do you think the Usurper-in-Chief went to OSHA and says, I want this taken care of and you're the agency?
I don't think Biden has a clue what's going on. I found it interesting on that point. They talked about running Hillary Clinton and Biden again. So Hillary would run again. We'd have a repeat of 2016. What I found funny about that is they're not even pretending to want Kamala.
I know.
They'd rather have this guy who's almost dead, who's not even there, than Kamala Harris.
But he's actually said that as much too. If you've been watching very carefully in the videos, there have been times when he said, I don't know why I'm here.
Yeah.
Somebody told me I got to call on this person first, and he has to look down at his notes to see who he's supposed to call on.
Yeah.
And I think the American people are catching on. The last poll I heard was that he has like a 33% approval rating, which I still can't believe it's that high, but still, that's pretty low. I mean, they were after Trump when he was 46. He's dropping like a rock. Well, 46 a lot higher than 33.
Yeah.
Lynn, there's something else. In the dissenting opinion, they were talking about how the Supreme Court is unelected and that they won't face the wrath of the voters, when they make this decision. Well, are they aware that OSHA is not elected either?
That's a very good point.
Okay. All right. I'm sorry. Go ahead.
Well, I mean, that's what we were talking about earlier with the ad hoc approach. It's like they're very utilitarian in that they'll use whatever is beneficial to them in the moment, and it's never principle. It's never the principle. So they'll use states when it's beneficial. They'll use the federal government when it's beneficial, Congress. But yeah, or with the filibuster, right? Like, how many times did they use it? I cited it in the last podcast. I embedded the actual number. I think it was like 300 times they used the filibuster. Trump, and now they're trying to get rid of it. So
yeah, did you see Senator Cotton? Was that today where he read a speech about defending the filibuster and how important it was? Did you see that at all?
I didn't see that. No.
Yeah, and guess who wrote it?
Who?
Chuck Schumer.
Wow.
Chuck Schumer gave that same speech when he was, whining from the other side. Now he wants to impose the filibuster.
Yeah.
That he's on the other side. Anyway, I just thought that was funny.
Yeah, well, there's another comment from Daniel. It says, I'm going to cite the Dungeons and Dragons handbook next. Clearly more authoritative confidence than the Constitution on this. But yeah, let's continue. I don't know if we'll finish the whole thing, but we'll keep reading. OSHA's determinations are conclusive if supported by substantial evidence. Judicial review under that test is deferential as it should be. So they're talking about Chevron deference right there. OSHA employs in both its enforcement and health divisions, numerous scientists, doctors, and other experts in public health, especially as it relates to work environments. Their decisions, we have explained, should stand so long as they are supported by such relevant evidence as a reasonable mind might accept as adequate to support a conclusion. Given the extensive evidence in the record supporting OSHA's determinations about the risk of COVID-19 and the efficacy of masking, testing, and vaccination, a court could not conclude that the standard fails substantial evidence review. The court does not dispute that the statutory terms just discussed, read in the ordinary way, authorize this standard. In other words, the majority does not contest that COVID-19 is a new hazard and physically harmful agent, that it poses a grave danger to employees, or that a testing and masking or vaccination policy is necessary to prevent those harms. Instead, the majority claims that the act does not plainly authorize the standard because it gives OSHA the power to set workplace safety standards, and COVID-19 exists both inside and outside the workplace. In other words, the court argues that OSHA cannot keep workplaces safe from COVID-19 because the agency, as it readily acknowledges, has no power to address the disease outside the work setting. I actually think that that's a good argument. I think that they're pointing out flaws in the majority's argument that we've recognized. If you are so vague in how much authority you think the Constitution has, or how much authority Congress has to defer to executive agencies, then you leave room for these criticisms from the more liberal side of the bench. They continue, but nothing in the Act's text supports the majority's limitation on OSHA's regulatory authority. Of course, the majority is correct that OSHA is not a roving public health regulator. It has power only to protect employees from workplace hazards. But as just explained, that is exactly what the standard does. And the Act requires nothing more. Contra the majority, it is indifferent to whether a hazard in the workplace is also found elsewhere. The statute generally charges OSHA with assuring, so far as possible, safe and healthful working conditions. That provision authorizes regulation to protect employees from all hazards present in the workplace, or at least all hazards in part created by conditions there. It does not matter whether those hazards also exist beyond the workplace walls. The same is true of the provision at issue here, demanding the issuance of temporary emergency standards. Here, just a second. Sorry, my roommate needs me to move his car, or my car, so I'm letting him move my car.
Well, I'm taking a couple breaks. It's only right for you to take a break.
Yeah. This is definitely my longest interview that I've had, or podcast that I've had, but let's keep going.
Sure.
Once again, that provision kicks in when employees are exposed in the workplace to new hazards or substances or agents determined to be physically harmful. The statute does not require that employees are exposed to those dangers only while on the workplace clock. And that should settle the matter. When Congress enacts expansive language offering no indication whatever that the statute limits what an agency can do, the court cannot impose limits on an agency's discretion that are not supported by the text. That is what the majority today does, impose a limit found in no place in the governing statute. Consistent with Congress's directives, OSHA has long regulated risks that arise both inside and outside of the workplace. For example, OSHA has issued and applied to nearly all workplaces rules combating risks of fire, faulty electrical installations, and inadequate emergency exits, even though the dangers prevented by those rules arise not only in workplaces but in many physical facilities. Similarly, OSHA has regulated to reduce risks from excessive noise and unsafe drinking water. Again, risks hardly confined to the workplace. A biological hazard here, the virus causing COVID-19, is no different. Indeed, Congress just last year made this clear. It appropriated $100 million for OSHA to, quote, carry out COVID-19 related worker protection activities in work environments of all kinds. That legislation refutes the majority's view that workplace exposure to COVID-19 is somehow not a workplace hazard. Congress knew and Congress said that OSHA's responsibility to mitigate the harms of COVID-19 in the typical workplace do not diminish just because the disease also endangers people in other settings. That is especially so because as OSHA amply established, COVID-19 poses special risks in most workplaces across the country and across industries. So I actually think that they're very logically consistent, and this is where this is the problem with having philosophers on the bench. If the majority isn't going to check Congress's power to defer authority to these executive agencies, then why not reason this way?
Right.
It's just if it just depends on how you feel that day, really. And I think that's why Gorsuch's opinion is so great, just because it is starting to question whether or not Congress even has the authority to give OSHA this power,
right?
Because it is so big.
Yeah, and if he's in fact making that argument, I think it's an excellent argument, and it's a question that needs to be asked over and over and over again.
Yeah.
Yeah.
So they continue that is especially so because, as OSHA amply established, COVID-19 poses special risks in most workplaces across the country and across industries. The majority ignores these findings, but they provide more than ample support for the standard. OSHA determined that the virus causing COVID-19 is readily transmissible in workplaces because they are areas where multiple people come into contact with one another, often for extended periods of time. In other words, COVID-19 spreads more widely in workplaces than in other venues because more people spend more time together there. And critically, employees usually have little or no control in those settings. During the workday, OSHA explained, workers may have little ability to limit contact with coworkers, clients, members of the public, patients, and others, any one of whom could represent a source of exposure to the virus. The agency backed up its conclusions with hundreds of reports of workplace COVID-19 outbreaks, not just in cheek-by-jowl settings like factory assembly lines, but in retail stores, restaurants, medical facilities, construction areas, and standard offices. But still, OSHA took care to tailor the standard. Where it could exempt work settings without exposing employees to grave danger, it did so. And the agency did just what the act told it to. It protected employees from a grave danger posed by a new virus as and where needed, and went no further. The majority, in overturning that action, substitutes judicial diktat for reasoned policymaking. The result of its ruling is squarely at odds with the statutory scheme. As shown earlier, the Act's explicit terms authorize the standard. Once again, OSHA must issue an emergency standard in response to new hazards in the workplace that expose employees to grave danger. The entire point of that provision is to enable OSHA to deal with emergencies, to put into effect the new measure needed to cope with new workplace conditions. The enacting Congress, of course, did not tell the agency to issue the standard in response to this COVID-19 pandemic because that Congress could not predict the future. And there it is. They're giving essentially just power for these agencies to do whatever they think. It's if the executive branch can issue an emergency for anything, whatever, like they would have the authority to do it under this opinion. And that's what we could have had. And that's what I think people need to realize. This is not a win. This is not a win. It's just another precedent to be added to the list of precedents they already have. Because under any other presidency with a different makeup of the court, if they expand the court, if they get more justices on there, this goes another direction, I think.
Absolutely. Yeah. And the 6-3 could easily, and would very likely have been 9-0.
Yeah.
8-1. I think Clarence Thomas would have held out.
And then Daniel's pointing this out again. What about the risks of heart disease from being forced to eat fast food or not being supplied healthy options by their employer? It could be anything. That's the exact point that I'm trying to make.
Right.
Do you want to keep going? There's 5 more pages left. I don't know.
How about you? I think just skip to the end and see if she comes up, or who wrote this? I can't remember already.
Yeah, let me see. I'll scroll up really quick.
Alito.
It's Breyer.
Breyer.
I don't know who would have. I think it's Breyer.
Okay.
So it's Breyer, Sotomayor, and Kagan.
Yeah, let's go with Breyer and see what his conclusion is.
Okay.
I mean, it's not like this isn't fun, but
Well, and it's also like we kind of get the point. Like I think I think we could summarize exactly what they were going to say before we even got to it, and we had addressed a lot of this while going over the controlling opinion, because it's just it's the way that they understand jurisprudence over the court. But yeah, let me just go to the last paragraph. It is funny, their dissent's much longer than the other opinions. And then there is this court. Its members are elected by and accountable to no one, and we lack the background, competence, and expertise to assess workplace health and safety issues. When we are wise, we know enough to defer on matters like this one. When we are wise, we know not to displace the judgment of experts acting within the sphere Congress marked out and under presidential control to deal with emergency conditions. Today, we are not wise. In the face of a still raging pandemic, this court tells the agency charged with protecting workers' safety that it may not do so in all the workplaces needed. As disease and death continue to mount, this court tells the agency that it cannot respond in the most effective way possible. Without legal basis, the court usurps a decision that rightfully belongs to others. It undercuts the capacity of the responsible federal officials acting well within the scope of their authority to protect American workers from grave danger. And there we have it.
When we are wise. So let's exclude Associate Justice Sotomayor from that right off the bat. And didn't Justice Kagan also, what did you say that she said? I can't remember already.
Yeah, there were many things. She said it's beyond settled that vaccines and masks are the best way to stop the spread.
Yeah.
And she also said she was the one who argued that this wasn't a vaccine mandate because they offered other alternatives.
Oh, okay. Yeah.
Yeah. But I mean, it's funny because like all of these authorities they're nowhere laid out in the Constitution, like we have said. And the fact that they're so willing to defer to executive agencies when they're the ones who gave those executive agencies the power. Like they're the ones who have ruled that we should defer to executive agencies because they are experts. This is a Supreme Court, like this is the creation of an all too powerful Supreme Court who has legislated and defined the federal government. Essentially, they've given the federal government this power
as being more and more and more powerful every decade since the existence of our country. They have given our government more and more power, our general government, and taken more and more power away from the states.
Yeah.
So yeah, go ahead.
Well, yeah, that was my main point, is just that like they have essentially created this technocratic government that we have where it's just ruled by experts. None of them are elected. They say in that opinion, it's like, we are not the elected branch, but as you mentioned, well, neither are these agencies.
Right. Well, and you can't even, there's no oversight. You can't even ask questions. Did you watch Senator Cruz talking to the FBI representative in Congress yesterday?
I heard about it, but I didn't get to read up on it.
Yeah, so he asked some very pointed questions, and I'm pretty upset with Senator Cruz, but he was asking most of the right questions of the FBI representative, assistant director, I can't remember, some gal, and she refused to answer any questions.
Oh no, I did see that clip.
Yeah,
I did see that clip.
They were even asking about Ray Epps, which we talked about on the January 6th one, and she wouldn't answer any of those questions. So Congress, once they give these people the authority, they can't exercise any control over them whatsoever. That woman wouldn't even answer his questions, and one of them, pretty easy question to answer, and she wouldn't do it.
Yeah, so, the question was the FBI involved on January 6th? We can't answer.
Yeah, Who's Ray Epps? I don't know.
Yeah.
So that's what gravels. It boggles the mind that they can't. These justices in this dissenting opinion can't connect the fact that they would give these people deference, these administrative agencies deference, but without oversight.
Yeah.
They have to be able to connect that in their mind, and I don't think they can.
So on one hand, they're creations of Congress, but Congress can't have any oversight over them. Yeah,
right.
All of it's a mess.
Right. It's just like states created the national government. We can't control them. It's kind of the same idea.
Yeah.
Well,
we've been going for about 2 hours. If you have any more thoughts, I think I'm done.
You're tired. Okay.
Yeah.
We should spend just a little bit of time, speaking of FBI, talking about that Oath Keepers. I don't know if you heard about that at all.
Yeah.
So I just want to briefly mention that because I think if I don't, I'll forget. And, the news cycle might change from these guys. But I do think that charge against in fact, I think there's 10, isn't there? Oath Keepers, I can't remember, is intended to have a chilling effect on the complaints about the national government's treatment January 6th and the prisoners there. And so anybody else wants to say, well, you want to come to the DC and protest, this is what you're going to get. So I think that's a significant story that, we should probably think about talking about one of these days. And
then I know that Ray Epps was an Oath Keeper. I think he was an Oath Keeper, and they're not interested in him at all.
Yeah.
So, and we kind of talked about that in the last stream. If anyone's listening, they should check that podcast out too. It was on January 6th, just talking about the year anniversary of it. I think it is silly that we're even calling it that, because it's like the fact that we're even making it up to be something more than it was is we've already kind of lost that conversation. There were some, I don't know. Did you read any of the opinions from more progressive people, what they thought about this opinion? I saw some tweets just saying that this was the worst. They expected that this is how the court was going to go. But did you have any things that you took away from reading articles or tweets or anything like that?
Yeah, I think we've covered most of it. Where was that? I had this pulled up here. Well, we're disappointed in the Supreme Court's ruling on our lawsuit against the healthcare worker vaccine mandate. That fight is far from over, and the case is still ongoing. So both of these things are actually still in the works, which I didn't understand when I first heard the ruling of the court today. So that's one thing. Let's see. I got it. Yeah, I can't find it anymore.
Was it the NBC article?
It was. I've got that up right now, but I just can't really remember exactly what No, this is the Epic Times article that I've got.
Okay.
I won't spend much time looking for it, because I think you're right. 2 hours is quite a bit.
Yeah, I'll just read a couple comments and we'll finish with that. I'll read a couple tweets and what people are saying, because it's kind of funny. Well, aren't we seeing what happens right now? Companies are whining about a lack of employees. Everyone just needs to get vaccinated and we will be done with this crap. Cool. So now the federal government lacks the authority to meaningfully manage a pandemic. God help us if something with 10 times or 100 times the mortality rate of COVID comes along. This was a partisan decision and short-sighted one. It will further undermine the legitimacy of the court. Oh my God, that's so bad. Since allowing individuals to control their bodies is all the rage now among the 6 conservative justices, I wonder when they'll block recent legislation to uphold Roe v. Wade.
Yeah, so we've talked about that too. That's an interesting argument that I always answer the exact same way. Well, I am all for bodily autonomy, and absolutely, the government shouldn't mandate what we put in our bodies. Or for that matter, necessarily take out of them, as long as we extend that courtesy to the babies in the womb.
Yeah. That's the answer there. Yeah, I saw another thing. I can't remember exactly what his argument was. But he finished with, it's time to take to the streets, is how he finished the tweet. And it was like, so this is what's going on in your mind. This is like the worst pandemic in the last century, and we're going to protest the government saying that you can't vaccinate people by going out and gathering in public. Like like I said, it's all ad hoc. There's no principle there. Um, they're utilitarians.
Right. They don't. The consistency of their principles is completely non-existent.
Yeah. Yeah. Well, we've been going for 2 hours. We're about to hit the 2 hour mark. 5 seconds and we'll be there. I had a lot of fun, and we'll definitely be doing this again. I told you that I'd have you back on. But yeah, I'd love to do it again, and maybe we'll talk about the FBI next week.
Sounds good. Yeah,
Cool.
just let me know.
All right. Well, thanks for coming on, and if you have anything else, please say it, and then if not, we'll see you later.
I'm good. Thanks again, Liam. Good night.
Good night.